on behalf of Virginia LERA. Um, we're happy to see everyone here for this is, I think, our second virtual program in 2025. Um, we do have, just wanted to mention for folks, we have our full day conference coming up in the fall. So mark your calendars, September 19th in Alexandria. We'll be having our full day conference again. Today we're happy to welcome Nicole Porter, who's going to us about the Americans with Disabilities Act and applying that in the workplace. And I think you all had an opportunity to see Nicole's bio. She's a national expert on the ADA. We're excited that she has, in the last year, moved to Virginia from Illinois. She was, prior to that, the director of the Malin Institute for Law and the Workplace at Chicago-Kent, and has now moved to Virginia and is at William and Mary. So delighted to have Nicole in Virginia, and I'm not going to spend any more time introducing her since you had a chance to read her bio, but I will turn it over to Nicole, and she has said she will take questions during the presentation if you want to ask questions, but we'll also save some time afterwards as well. So feel free to ask if you want to raise your hand or put something in the chat. During the presentation, that'll be great. But we'll also save time at the end. So I will turn it over to you, Nicole.
All right, thank you. Can you all see my screen?
Yes.
Okay. So thank you, Anne, so much for inviting me to do this. I'm always happy to talk about the ADA, and always happy to have a new audience to sort of share a lot of my research, which basically almost everything I'm going to talk about today are things that I've been working on or will be working on in the very near future. So I have probably an overly ambitious agenda, but I know where we can skip things if we're running out of time. And so we might not get through all this, obviously, but we're going to talk about the definition. I've done a lot of research there, a lot of empirical work. I'm kind of going through sort of like the elements of a claim. So we'll talk about the qualified inquiry, and there's a bunch of unresolved issues regarding the employer's accommodation obligation. I'll talk a little bit about employer defenses if I have time, but that one's not as pivotal. Not a whole lot going on in the law with that right now. And then just briefly, I'm working on a paper right now about the effect of Loper-Bright on the interpretation of the ADA. So with that ambitious agenda, I'm going to start with the definition. And as I get to each part, if you have questions about the definition section, maybe you ask me then instead of waiting until the end. But whatever works for you, I'm fine with. So I like to talk about the definition as being on a roller coaster ride. It is a metaphor I came up with in my recent book. So the ADA is passed in 1990 with this sort of overwhelming bipartisan support. Here's the definition of disability: a physical or mental impairment that substantially limits one or more major life activities. That's what we call the actual disability prong. The record of prong is still part of the statute. I just crossed it out because it never matters, or almost never matters. And then being regarded as having such an impairment is still relevant. So the Supreme Court and lower courts, as I'm sure many of you know, gave the definition of disability a very narrow interpretation. We must consider someone in their mitigated state, meaning if they take medications, etc. And then Toyota, a couple years later, after the Sutton trilogy, said we're going to interpret the definition of substantially limits very narrowly. We want, it has to prevent or severely restrict the person from doing activities that are of central importance to their lives, and then it must also be permanent or long-term. We also had a very narrow interpretation of the regarded as prong, so it was very difficult to prove that. Congress didn't like this, and so they passed the ADA amendments with the purpose of dramatically broadening the definition of disability. So like right now in 2008, for those of us who write about this and care about it and care about sort of the disability rights perspective, this was, depending on what you feel about roller coasters, that was like the top of the roller coaster, right? Everything was great. Okay, so some key provisions in the new act that I'm seeing so many attorneys get wrong. And so anytime I can educate people, I like to do that. So one of the things is Congress is very explicit. We're overruling Toyota's statement that the ADA needs to be narrowly construed to create a demanding standard. Instead, it shall be construed very broadly. Overruling the Sutton court should not consider mitigating measures in determining whether someone is substantially limited in a major life activity. It broadened the definition of major life activities, so anything you see in italics is new to this statute, wasn't part of the original. So the new ones, eating, sleeping, standing, lifting, bending, reading, concentrating, thinking, and communicating. And then really sort of, in my mind, ingeniously, they added in this provision that says major life activities include the operation of major bodily functions. And so this allowed things that courts would routinely see as not disabilities, things like cancer or hypertension or diabetes. They allowed those things to be seen now as a disability, even if it doesn't have an outward manifestation, unlike your everyday daily activities. If it's something going on inside your body is substantially limited, so someone who has diabetes, their endocrine system is substantially limited, then that's a disability, even if it wouldn't necessarily affect something that we see from the outside. And then they also added in this provision that said that an impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. So this is really relevant for cancer, which can go into remission, or things like multiple sclerosis or other types of diseases that are episodic, that flare up sometimes and not other times. So that was really pivotal too. And then the revisions to the regarded as definition, the old law was that the employer must have perceived the plaintiff as being substantially limited in a major life activity. It was really hard to get a defense witness to testify to that. Like any well-counseled defense witness would avoid saying, yes, I knew that person had diabetes, but they're going to not say that they thought they were substantially limited in some major life activity. And so it was really hard for plaintiffs to survive dispositive motions. So the new law says that you can meet the regarded as provision um, if you have an actual or perceived physical or mental impairment, and then the italicized language is what's important here, whether or not the impairment limits or is perceived to limit a major life activity. So again, that was a very pivotal, basically brings the ADA, it's much closer now, the regarded as provision is much closer to Title VII coverage, right? Which covers everyone based on protected classes. Everyone who has an actual or perceived impairment should be protected by the regarded as provision. In exchange, though, for this very broad coverage, two things. The regarded as definition is not met if the impairment is both transitory, which is defined as 6 months or less, and minor. Not all courts get the and part, which unfortunately minor is not defined. And then the other concession is there is no right to a reasonable accommodation under the regarded as prong. So the EUC says, hey, if you don't need an accommodation, you should definitely be proceeding under the regarded as prong because that's so much easier. You don't have to prove a substantial limitation. Okay, so I somehow have talked myself into and had other people talk me into literally every 5 years, I do an empirical piece. So the first 5 years, so that would have been 2009 to 2013, mostly positive. I walked away from that thinking, wow, courts are really following Congress's mandate to broadly interpret the definition of disability. So very happy about that. Then I started looking at the second 5 years. This was actually sort of accidental, although then I ended up looking at it in more detail. And it was certainly a drastic improvement over pre-amendment times where almost, virtually nobody was disabled. I'm still seeing way too many errors. About 1/5 of the cases, courts got it wrong. And often the way they got it wrong was that they just didn't recognize that the amendments existed at all. And then I just finished writing this last year. It just actually is getting published probably any day now. The third 5 years, so 2019 to 2023, still sort of disappointing in my mind, slightly improved in some ways, worse in others. Several new troubling trends, as I call it. And so 214 out of the 1,205 cases, or 18%, were incorrectly decided. Um, so citing to the incorrect law is one of these huge problems, and it's just baffling to me that that courts and lawyers still don't know that this law exists. So in the 2014 to 2018, about 42% did not cite to the 80 AAA or any of its provisions. And then in the 2019 to 2023, actual disability 45%, regarded as 44%. So a very high number of cases are not even recognizing that this very substantial amendment had been passed, which is frustrating. And again, sort of a little mind-boggling. And then the other thing, this word phrase shadow precedent comes from another professor, Deborah Whitus. Basically, it refers to old law. So like Toyota and Sutton are no longer good law, but they still show up in post-amendment cases. And sometimes they show up directly, like the courts citing to them directly, but often they're citing to cases that cited to Toyota and Sutton, and therefore they're getting it wrong. So I saw this in 127 out of 194 actual disability cases in this last piece. Some examples were requiring an impairment to be long-term, which is no longer good law, saying that a specific activity like lifting is not a major life activity, even though it clearly is under the new statute. 53 out of 98 regarded as cases cited to shadow precedent. And so that big change of whether or not the impairments limits or is perceived to limit a major life activity, lots of courts are still getting that wrong. So examples being awareness of the impairment is not enough. The employer must subjectively believe that the impairment substantially limited major life activity. No, that's not the law. Okay, so some recurring errors that I saw in the 2014 to 2018 and this latest one, and some of these I've written about separate, like disclaiming disability. Often plaintiffs say things that end up tanking their cases. They'll say like, oh, I can still do anything I used to do in like a deposition or something, or I can still work. And then the court says, well, if you can work, you're not substantially limited, even though they might not have even claimed working as a major life activity. So we're seeing that quite a bit. Lots of courts criticizing plaintiffs for having insufficient medical evidence, even though the EEOC says in most cases you shouldn't need medical evidence. The impairment is too short term, again, even though Congress, basically said Toyota is no longer good law. And then lots of pleading problems on obviously it's plaintiffs who are doing the pleading, not using major bodily functions provision when it would be the most straightforward way to prove disability, focusing on working when it's actually really hard to prove working as a major life activity that's substantially limited, or sometimes not even identifying the impairment or what major life activity was substantially limited. Some of those, I think are easily avoidable. And then courts are often getting the regarded as analysis incorrectly. So, saying that knowledge is not enough or incorrectly applying that transitory and minor affirmative defense. So some new things that I saw in this last 5-year set or data set is not believing the plaintiffs. So not believing them about their limitations, even though all of these were at the dispositive motion stage, we should be, interpreting them in favor of the facts as, from the plaintiff's perspective, construing the facts from the plaintiff's perspective, but lots of courts saying, no, the plaintiff said this, but basically just we don't believe it because there's no other evidence about that, about their either limitations or pain. I'm seeing a lot, and this is something I think is intriguing that I want to write about in the future, what I call medical evidence mismatch. And this is really, I think, the legal profession and the medical profession are not talking to each other well. And so the legal profession expects all doctors to give a very specific diagnosis, and often doctors don't and won't, especially if it's mental illness, because sometimes, there's philosophy out there that can actually make it worse if we actually give you a specific diagnosis. Requiring the doctor to use the statutory terms, substantially limited in a major life activity. Doctors don't think in terms of our legal definitions, nor should they, in my mind. Questioning the existence of an impairment. This is new, right? The impairment used to be the easy part. The hard part was the substantially limits a major life activity. But now I'm seeing courts saying things like a heart attack, stroke, seizures, traumatic brain injury are not even that sort of first easy step of impairment, which is troubling. Not a disability if the employer causes it. It's a bit of a flip title, but lots of cases where a plaintiff's mental illness has been exacerbated, or maybe they didn't have one and now they have a mental illness. because of something happening in the workplace, and the courts say, nope, if what's happening, if your mental illness is being caused at all by something going on in the workplace, you don't have a disability. And then my sort of overarching a lot of effort to be wrong. And this is the one that I'm worried about, what we call another backlash, right? We saw a backlash against the original ADA, and that's why we saw that narrowly construed definition. And there's some concern that that might be happening again. Maybe too early to tell. Um, so, what's causing the problem? That's part of what I try to address in my latest piece. Um, and it's hard to know, are these mistakes accidental or are they intentional? If they're accidental, such as not citing to the ADA amendments at all, well, that's likely caused just by a lack of education. Not enough people know about them, even though, again, they've been around since 2008. If the mistakes are intentional, the court cites the correct law but misinterprets it or finds some other way to find the plaintiff not disabled. I'm still unsure whether this is motivated by a desire to control their dockets, which isn't right, but perhaps a little bit more understandable and better than another backlash against ADA plaintiffs. Of course, it's really hard to tell. Um, so if it's accidental mistakes, okay, we should be able to solve that, right? So we need more lawyers and judges educated about the ADA and the definition of disability. Obviously, that starts in law school. I teach a freestanding disability law class. I cover in depth the ADA when I'm teaching employment discrimination, and I encourage my colleagues to do the same. But I also think we need more CLE training, or even things like this. I don't even know whether this is CLE or not, but we need more CLE training. We need lawyers and judges to understand all of these significant changes. Um, if it is possible solutions for intentional mistakes, the Supreme Court could, whether this Supreme Court will is an open question, of course, but could or should resolve this long-term mistake that courts are making, where they still say that an impairment needs to be long-term in order to qualify as a disability, even though the EOC makes clear that that's not the case. And then because Chevron deference has been obliterated, Congress, I think, should amend the ADA to define substantially limits. So instead of defining it in the statute itself, they debated, couldn't come up with anything, and basically punted and said the EEOC is going to define substantially limits in the regulations. And so there's a concern, of course, and this is a piece I'm writing this summer about what's the effect of Loper Bright. And so because substantially limits isn't defined in the statute itself, it's only defined in the regs, I can easily see that becoming a narrower definition again. Okay, so I'm moving on to the qualified inquiry, but I thought I'd pause briefly. I don't see any hands up. I see there's one chat, but I don't have the chat open because my computer screen's not big enough. But
No, the chat's just about the Pope, so you're good.
oh, okay, good. All right. Okay. So again, feel free if you have questions just to raise your virtual hand. I think that'll make you go to the top. I do have a little strip of faces on the side of my screen. Okay, so the qualified inquiry is another sort of big area where we see tons of litigation. And so, as I'm guessing many of you know, only qualified individuals with disabilities are protected from discrimination and entitled to reasonable accommodations. But qualified is defined much more stringently here than it is under Title VII. So, qualified means able to perform the essential functions of the job with or without reasonable accommodations. As you might imagine, one of the big push points or pressure points is figuring out what are the essential functions of any particular job. And that often is like where all the litigation is trying to figure that out. So, um, why does it matter? So, the EOC defines it either as an essential job function or a marginal job function. It matters because an employer is obligated to excuse the non-performance of a marginal function or to accommodate it by having someone else do it. But if it's an essential function, then the employer is not obligated to excuse the disabled employee's inability to do that function. And they're not required to put that function on another employee. So figuring this out, whether or not a function is essential or marginal, is really, really pivotal. And so we have both statutory language and regulatory language. So the statutory language says that consideration shall be given to, doesn't say complete deference, right? But consideration shall be given to the employer's judgment as to which functions are essential and any written job descriptions if they were prepared before the company started advertising for or interviewing for a particular position. So employers are incentivized to write job descriptions. Um, Unfortunately, that often means they write really, really broad job descriptions so that they can allege that almost anything is an essential function. Um, and that and that has been a problem in many of the cases. The regulations sort of elaborate. They include, of course, those two statutory factors of the employer's judgment and written job descriptions. But then they add in the amount of time spent on the job performing the function. Is this something that only has to happen once a week, or is it something that happens, for 4 hours every day? That's obviously very different. The consequences of not requiring the incumbent to perform the function, so I don't know, think of something that we all know about, right? Like, so an attorney who is like has an anxiety disorder about being in trial. And but they can do everything else about litigating a case. They can do depositions, they can argue in court, but they just have this extreme anxiety that rises to the level of a disability about being in trial. You're not going to see many cases go to trial, right? Anymore, like in federal or state courts. Arbitration obviously is different, but so we might say, well, you don't do it very often. But if the person can't do it, the consequences might be quite severe, right? So they've been litigating a case for 2 years and now it goes to trial and they can't do it anymore. And so someone else, so you can see the sort of the push between or the conflict, the tension between those two. How much time is spent doing it, maybe might be very little, but if it's really important, the consequences are very bad. If the employee cannot do the function, even though it only happens rarely, that's going to be a different situation. If there's a collective bargaining agreement, doesn't obviously happen very often, the work experience of past incumbents in the job or the current work experience of incumbents in similar jobs. And this is one of the EEOC regulations that I'm a little bit worried about after Loper Bright, because the EEOC really does expand on the statutory factors. So whether or not a court says that the plaintiff can do the essential functions or not really depends on how much deference they give to the employer. So if they are only citing to the statutory language and they say, the employer's judgment is what's pivotal here, they might not even cite to the EEOC regulations at all, or if they do, they might just give them no attention. And they just frequently, I'm seeing, because this is one of the things I'm writing about right now, courts are saying, the employer's judgment is most important. They're the ones that made up the job, decided what the job was. And the more deference a court gives to the employer, the more likely the plaintiff loses, because the employer can say, here's all these things that are essential functions. And even if there's lots of evidence that goes the other way to show that they're not essential functions, if the court is only deferring to the employer, then the employer wins and the plaintiff loses. So it really has become a hotly debated issue. Okay, so I'm gonna, again, unless there's questions, I'm gonna move on to some unresolved accommodation issues. So here's the statutory definition. It's not really, doesn't define reasonable accommodations, it just gives some examples. So reasonable accommodations can include obviously making existing facilities accessible. So obviously this would most likely be for individuals who are in wheelchairs or other mobility impairments. And then a bunch of other things. So job restructuring, part-time or modified work schedules, reassignment to a vacant position, acquisition or modification of equipment or devices. So maybe someone needs software to uh, allow their screen, print to be larger if they have a vision impairment, et cetera. Changing examinations, training materials, et cetera, provision of qualified readers, which we don't really see anymore because of technology, or interpreters, which we do see quite a bit, and then other similar accommodations for individuals with disabilities. So it's a kind of pretty broad list, but again, there's no specific definition about how we define what is a reasonable accommodation or not. Okay, so one of the hotly, and I'm sure this is no surprise to you, given what's gone on, during and after COVID, remote work is just constantly being debated. All right, so I have one case here. This is a case that's in the new edition of the casebook that we just finished. And this is a case that even though the plaintiff loses, I think the court still does a good job with its analysis. It says we're no longer going to follow the general rule that remote work is not a reasonable accommodation, because that's been the general rule since mid-90s. Instead, we're going to ask whether the essential functions of the job must be performed in person. So they were doing a much more individualized analysis about whether or not this job could be performed remotely most of the time, and or does it have functions that have to be performed in person? And the court recognized in this case that COVID did teach us that many jobs we thought that must be performed in person can be performed remotely. We can do meetings, right? We can do. I'm guessing these would have taken place in person, before we all knew how to use Zoom. But the fact that employees were able to temporarily work from home during the pandemic doesn't mean that those jobs do not have essential functions that require in-person presence. So the court ultimately said that she could not perform the essential functions because she was supervising a radiology department in a hospital, so like some 100 employees, and she was a liaison between that department and other departments. And because everyone else was in the workplace, not, just on a computer, then the court, I think, sensibly said she could not perform those functions from home. Other people were having to tell her about problems so that she could address them, things that she would have known had she been there in person. So I think this is a good case. On the other hand, I have a friend slash colleague, a professor, Deandra Shue, who's been researching this since the pandemic. And she was on sabbatical. She was in Hawaii, but she was kind enough to share with me her very recent results that are not published anywhere yet because she's still working on it. But she's looked at all federal cases from 2023 to 24 that rule on a remote work accommodation request. Employers won 60.4% of the time, and employees survived a dispositive motion the other 39.6%. And then she also told me that this is worse than her research that went from April 2020 to the end of 2022. And she did note that employees are surviving motions to dismiss more than motions for summary judgment. I guess that's good because then maybe there's that settlement potential in between the motion to dismiss and the motion for summary judgment. Um, but frustratingly, she said that more than half the courts still used that presumption, that general rule that I was just talking about in the Kinney case, that physical presence is an essential function of most jobs and therefore remote work is not a reasonable accommodation. There's still over half the courts were still using this presumption without mentioning how COVID affected everything, right? What COVID had to say or had to teach us about whether or not a particular job could be done from home. It's almost just like, head in the sand, just going to pretend like COVID never existed and we never learned all the lessons that we learned. So that was, I thought, disappointing results. Where we end up is, I think, anyone's guess, to be honest. I don't think we'll ever go back to as much hostility towards remote work as we had before COVID, but I don't think we're going to improve as much as I think many of us thought and hoped that we would. And lots of people need a remote work accommodation for their disability. There's just many disabilities for which that might be the only accommodation that would be effective for that employee. Okay, another pressure point issue are leaves of absence. And this, obviously is going to interact and intersect with the Family Medical Leave Act. The EEOC's guidance says that providing a leave of absence is a reasonable accommodation, even if the leave goes beyond the employer's normal limit. So if an employee needs additional unpaid leave, the employer then must modify its no-fault leave policy to provide that additional leave unless it can show that there's some other accommodation that would work, or granting additional leave would cause an undue hardship. In other words, employers are required to modify workplace policies, is the EEOC's position, including leave policies, as a form of reasonable accommodation. Unfortunately, the law is not nearly as clear as the EEOC guidance, and so I don't know if everyone would call it a circuit split, but I think we're really seeing one develop. So you have courts that, like the Garcia, like the First Circuit case here, that leave beyond FMLA and beyond the expiration of a short-term disability might short-term disability policy might be a required accommodation unless the employer can show undue hardship. So in the Garcia case, she had a job that could easily be filled in by temporary workers, and they weren't paid more or anything like that. So it wasn't costing the employer anything extra. Her leave wasn't paid, of course. And the court said, no, you can't prove undue hardship. In that case, it's not a big deal that you're, using these. I mean, obviously, temporary workers don't work for a lot of jobs, but they do work for some. So other circuits that I think still follow this, the Ninth, Sixth, maybe the DC, some of these cases are hard to figure out. And then we are really seeing this push, and I realize I don't have anything on the Fourth, and I don't know that I've seen a definitive decision yet out of the Fourth Circuit. But the flip side is came out of the Seventh Circuit, and there's also a 10th Circuit decision that's just as sort of stringent, which is leave beyond 12 weeks allotted by the FMLA is not a reasonable accommodation because it would not allow the employee to perform the essential functions of their job, and emphasizing that the ADA is not a medical leave entitlement statute. Okay, I mean, yes, the FMLA is a medical leave entitlement statute, but as I'm sure many of you know, almost 40% of the population doesn't have an access or right to FMLA leave, and the court kind of ignores that. So if they're saying that leave beyond 12 weeks is never a reasonable accommodation, what would happen if the employer wasn't covered by the FMLA at all, right? They had more than 15 to be covered by the ADA, but fewer than 50 to be covered by the FMLA. I think that those employees in these circuits are just out of luck. Like most of these cases will say a very short leave, like a week, maybe 2 weeks, okay, but anything beyond that is going to be unreasonable. And so many disabilities will have periods of time where someone needs a leave, right? Like someone's going through cancer treatment and, maybe they were able to get through chemo and radiation while still working, but then they need surgery and they need to recover. That person doesn't have access to FMLA leave, they're going to be fired. And so, I see this as being an important issue. I do see it coming up to the Supreme Court at some point in the, near to midterm future. Judge Gorsuch, when he was on the 10th, Justice Gorsuch, when he was Judge Gorsuch on the 10th Circuit, authored one of the opinions that said a leave of absence is not a reasonable accommodation. So that might have some predictive value as to what the court will do if it decides this issue. Okay, so that's another. So another sort of unclear, unresolved accommodation issue is reassignment to a vacant position. So the starting point is, reassignment is listed as a reasonable accommodation. If you can't do your current job with other accommodations, then reassignment to a vacant position might be reasonable. You don't have to promote anyone to do that. You don't bump anyone out. But if they are qualified and it's vacant, the EEOC's position again is that they should be assigned to that vacant position. As many of you know, really the only Supreme Court case that addressed an accommodation issue at all was U.S. Airways versus Barnett in 2002, where the court said, okay, yes, reassignment, yes, that can be a reasonable accommodation, but not if it interferes with another employee's rights under a seniority system. And that's true whether it was a collective bargaining seniority system, which of course the vast majority of them are collectively bargained for, or in the case of this case, a unilaterally imposed seniority system. Okay, I don't necessarily agree with that, but that's been the law, right, since 2002. But then a separate issue arose. What if reassignment interferes not with any other employee's seniority rights, right? They don't have sort of a vested interest like you would if you had a seniority system in place, but it interferes with an employer's policy to hire the most qualified for the position. So an employer has a vacancy. 10 people apply. One of them is a disabled employee who, if they don't get that assignment, is going to be terminated because they can no longer do their current job, even with other accommodations. And the employer says, well, yeah, you're qualified. And they get to set the qualifications where they want, right? Yes, you're qualified, but oh, we think this other person is slightly more qualified. What happens? Well, we have a circuit split on this as well. And this one was almost, so that's 4th, 5th, 8th, 11th versus 7th, 10th, and DC, and we're seeing more courts saying not a reasonable accommodation in recent years. Um, so that opinion, so the Huber versus Walmart stores was one that some of you might know was cert was granted, and it was like, oh, this is going to be interesting to see what the court does. But then the party settled, so it was dismissed. So at least at one point, the court showed interest in taking this issue. Um, and so Huber's position is the ADA only requires the employer to allow the disabled employee to compete for a vacant position, but does not require the employer to turn away a superior applicant. And they say any other rule would be affirmative action with a vengeance. And this conclusion, they say, is bolstered by Barnett because seniority systems are similar to most qualified policies. That's half, that's the one half, although now the larger half of the circuit split. The other side is exemplified by the Seventh Circuit decision, um, where the court says seniority systems are different from best qualified policies. So a seniority system, employees have a vested interest in that vacancy, right? They know that they are the next one in line for that vacancy because it's all very transparent. But with a best qualified policy, no employee can say that they have a vested interest in getting a transfer to that position unless they're really, really arrogant, right? Like unless they think for sure that they are, the most qualified. But these are subjective decisions. So I don't think any employee can really say, I have a vested interest in this position. And that's the distinction that this Seventh Circuit makes in this case. So they say, while employers may prefer to hire the best qualified applicant, the violation of a best qualified selection policy does not involve the property rights and administrative concerns presented by the violation of a seniority policy. It affects the employer more, but it doesn't affect the employee's interests. And so like I said, I don't know what to think about when this will get decided by the Supreme Court and which way they'll go. Although my guess is they'd go in favor of Huber, at least the Supreme Court. Um, okay, and then the last sort of unresolved accommodation issue are accommodations that are not strictly necessary to perform the essential functions of the job. And so I already showed this, but just so you see the examples again of what accommodations might include. And one of the things that we're seeing are these challenges to one of the EEOC's regulations. So if you everything in A is about making facilities accessible, and then B is sort of like everything else, but having to do with the ability to perform the job itself. The EEOC divides it up into these. So the first one is regarding accessibility, right? Or application is what I should say there. And then the second one has everything to do with the work environment, but is specifically focused on allowing the employee to perform the essential functions of the job. And that's the one that we see the vast majority of litigation under. But the EOC has also said that modifications or adjustments that enable a covered entity's employee to enjoy equal benefits and privileges of employment as are enjoyed by similarly situated employees without disabilities. So, um, so easy example, let's imagine an employer has an on-site cafeteria and they have a new employee who uses a motorized wheelchair. So, tend to be bigger than a regular manual wheelchair. And the entrance to the cafeteria is not wide enough for the person's wheelchair to go through. The employer might say, well, you don't need to use the cafeteria in order to perform the essential functions of your job. And maybe they even offer to assign somebody to like go and fetch them lunch and bring it to them in their office or cubicle or whatever. But we can see the sort of segregation, isolation, stigmatization that can happen if we tell someone, no, you cannot go into the cafeteria where all your coworkers and friends are eating in the cafeteria. We're not going to make that accommodation because you don't technically need it to perform your job. This is just one example. Again, I'm writing about this right now because I do think it's a really interesting issue that probably not right away, because I don't think it's gotten to the point where we can say there's a circuit split, but I think we will see a lot of litigation on this in the future. So one side is this Brumfield case. A plaintiff cannot state a failure to accommodate claim against her employer if she's able to perform all of the functions without an accommodation. Therefore, the employer's duty is triggered only if the individual needs an accommodation to perform the essential functions of the job. And so they cite to that second one, but not subsection 3, which was the third one that I was just talking about a minute ago. And dozens of cases have cited this rule favorably. It's an odd case because we don't even know what the accommodation that the plaintiff was requesting, but it is a troubling one because we've seen a lot of courts follow that. And then when courts actually cite to that subsection 3, the equal benefits and privileges of employment, then they generally defer to the regulation. They don't even usually talk about it in terms of deference, but they follow the regulation and they will require an accommodation even if not needed to perform the essential functions. And the most common fact patterns here might be a sign language interpreter, maybe for like meetings or social events, but they don't need it to actually, perform their daily tasks. Being allowed to have a service dog at work, transfers to seek better medical care, accommodations related to the accessibility of a building, and accommodations that are needed to allow the employee to do the job with less pain. So those are some of the common fact patterns we're seeing and that I think are going to come to a head at some point. Okay, I'm at 144. So I'm going to skip by the defenses because I think not seeing a ton of litigation, the undue hardship defense, everyone thinks it's this big deal, right? It's the limit on the accommodation obligation. It's almost never dispositive. I did research on I don't know why I take on these empirical things that take forever, reading tons of cases, but it's almost never dispositive. And so there's really nothing there. There's no circuit split there. There's nothing significant going on. The direct threat defense, employers don't have to hire someone if they pose a direct threat to the health or safety of themselves or others in the workplace. It's supposed to be a very hard defense to meet. And it usually is, right? You usually have to show that, that we're going to look at the duration, the nature and severity of the harm, the likelihood that it will occur, the imminence of the potential harm. Common disabilities might be HIV. We saw this in the prior, 90s. We don't see these cases very much anymore. Epilepsy, someone's afraid of someone having a seizure when they're doing a safety sensitive job. Diabetes, same thing. Mental illness, this is usually a fear of some kind of violence. So litigation, yes. Again, there's no circuit splits there. There's nothing sort of really definitive that's going on. So I will spend, because I want to stop at 150 so that we have time to take questions. But I do want to talk a little bit about the effect of Loper-Bright on the ADA regulations. So I'm sure all of you know this. Loper-Bright overruled Chevron's two-step inquiry that was used when interpreting statutes in light of agency regulations. But when I've talked about this with my administrative law professor friends and colleagues, they all said, no, the EEOC's ADA regulations should be safe because of this statement in Loper-Bright, where the court is talking about express delegations. And it says, if the Congress expressly delegates to an agency the authority to issue regulations about some specific law, like has happened with both Title I of the ADA in the original ADA and with the definition of disability in the amendments, right? That Congress has specifically given the EEOC the authority to issue those regulations. So the court says, in those cases, the court must independently interpret the statute and effectuate the will of Congress. The court fulfills that role by recognizing constitutional delegations. We're fine there. Fixing the boundaries of the delegated authority and ensuring that the agency has acted, that the agency is engaged in reasoned decision-making within those boundaries. So my concern, and I identify, this is the paper I'm working on right now, 3 vulnerable regulations where I think an argument can be made that the EEOC's regulations go beyond the statutory definitions. in one or more of these areas and therefore sort of exceed those boundaries. That's the concern. So the EEOC's definition of substantially limits is really broad. And there's a regulation about short-term impairments can still qualify as disabilities. So that's one that I see as vulnerable because Congress still used substantially limits, but the EEOC defines it in a way that doesn't sound anything like substantially limits. And so that I think can be challenged. The one that we talked about earlier, the EEOC's regulation regarding the factors that courts should consider in determining essential functions. I can see some employers saying, well, Congress only mentioned those two factors. The EEOC has exceeded their authority by bringing up other factors that courts should consider. And then finally, the one that I was talking about just a minute ago, the EEOC's regulation regarding reasonable accommodations that allow a disabled employee to enjoy the benefits and privileges of employment. Again, goes beyond the statutory language. And so I think there's a concern there as well. All right, I think we got done with 1 minute to spare before I was wanting to make sure I was done by 1:50, so we had time for questions. Hopefully I didn't talk too awful fast for all of you, but I'm going to stop my share. By the way, if anyone has thoughts or questions that you don't get to ask or can't ask right now, please feel free. My email's up there. I'm also very easy to find online at William & Mary, so feel free to reach out. I'm always happy to talk about these issues.
Great. So, do folks have questions? Just feel free to speak up or raise your hand, or put a question in the chat if you like. Well, I'm not seeing a question immediately, so let me ask one. So I guess as I'm listening to this, I'm thinking about sort of where we're likely to see the Supreme Court address the ADA first. Do you have thoughts about sort of the next issue that we might see the court addressing?
I think I think the leave of absence is a strong possibility, as is the remote work. Because I just think remote work is just being talked about a lot. Now, the problem with the remote work one is I don't think we've seen enough case law after COVID that, we don't have a circuit split yet or anything like that. So that might not be exact, but I do think that one's going to be really pivotal in the future. But probably the leave of absence or that best qualified policy with respect to reassignment because, and my only reason for saying this is because the court granted cert on it before, right? They granted cert on it before in 2007. So to me, okay, well, you were willing to hear this issue and decide this issue back then. If nothing else, we have more of a circuit split since then. More circuits weighing in. So that's probably, I think, and that example is like kind of really prime for decision because it really is a circuit split. There's not like a bunch of fuzzy opinions. You have sort of, two different sides to it. So I think that might be, a high likelihood. The definition stuff that I'm talking about, some of it might come to a head eventually, but I still think the lower courts are still kind of grappling their way through it, right? They don't really have we don't have enough out there. Like the short-term thing, if we start seeing some circuits that say it still has to be long-term, that might, end up before the Supreme Court. But right now is all we have is a bunch of district courts that get it wrong, or the circuits that actually decide it are getting it right and saying it doesn't have to be long-term in order to be a disability. So, that might end up coming to a head if you get some circuits that in published opinions go the other way. But right now, they're either the circuits that haven't decided, which is almost half of them. You only have district court decisions or you have unpublished courts of appeals. So I think that's going to need a little bit more time before that percolates up for sure.
And I guess my other question is, given all these areas where there's, I mean, not just uncertainty, but where you're saying the courts are just plain getting it wrong.
Yeah.
uh, Like, what should employers do in terms of
Oh, yeah.
applying this in the workplace?
Yeah, so this is I'm okay. So there are lots of um sort of solo practitioner plaintiffs attorneys. And from my days of practice, a lot of them are overworked. They have too many cases. I also saw something when I was in practice. I don't know how often this happens anymore, but my sense is it happens a little, where someone doesn't normally do disability law cases. Maybe they don't even really do a whole lot of discrimination cases, but then they'll take one and they really don't. I call it dabbling in disability law because it's not an easy topic to really learn on your own. And so they haven't been doing any of it. Maybe they didn't take any classes in law school, and they're sort of muddling through. And I think that that's sort of part of the problem. And courts, like, all right, courts, you have a judge for every district court case. There's a bunch that were pro se plaintiffs, but for most of them, you have four attorneys who are looking at this, right? You have the plaintiff's attorney, the defense attorney, the clerk, and the judge. And that's a lot of people to get it wrong. And I think most defense attorneys know the law, and sometimes the court will call them out on it. Defense attorney, or you guys are citing to law that is no longer good law after the amendments. And I think I do find that, like, there's an ethical rule that says if you know of authority that is adverse to your client, you're and the other side doesn't disclose it, you're supposed to disclose it. And I'm shocked at how often that's not happening because most defense side attorneys, they're not just dabbling in this. This is what they do day in and day out. They know, they had bulletins when the ADA was amended, right? Like, they know the law at varying levels of expertise, but they know it. And I'm really troubled by that because you shouldn't, even if the person, we say they have a disability, and to be fair, plenty of employers are conceding that issue, as they should in many cases, because we've now expanded that definition so much that I think in most cases the employer should just be conceding it. Um, so that's good. But yeah, even if the plaintiff is sort of survives a dispositive motion on the disability question, they still have the whole rest of their claim to prove. And there's often obstacles there, right? There's the essential functions obstacle, and there's the what's the accommodation? Is that a reasonable one? Is there some defense? Like, so there's so many other things. Like, I've always been a little bit perplexed by this kind of push for a narrow protected class under the ADA, especially under the regarded as prong, where you're not allowed to accommodations. We're still seeing a narrow protected class when everyone's protected under Title VII, right? Like, everyone has a sex, everyone has a race, everyone has a religion or no religion, right? Everyone's protected under Title VII. And it's just been mind-boggling to me. Why are we so afraid of a disability protected class? And I think the answer for actual disability claims is, well, then the employer is required to do something affirmative, right? Give reasonable accommodations. But we're even seeing this sort of pushback in the regarded as cases where they're not entitled to reasonable accommodations and they don't need them. And so that's been sort of very sort of perplexing to me. Why are we fighting so much about this issue that really should just be kind of an easy one? That's exactly what Congress was trying to do.
Mhm. All right. Any other questions from folks? Let me just quickly scroll through here. Let's see any. Well, we're about out of time. So thank you very much, Nicole. Really
You're
appreciate
welcome.
it. It's been a fabulous presentation, and we're delighted to have you here in
Thank
Virginia.
you.
Um, and thanks for speaking to us today.
Yeah,
Um,
you're welcome.
For everyone else, just a reminder, put on your calendar the Virginia LERA Conference, September 19th in Alexandria. Hope to see everyone there. And, we'll be doing some more virtual presentations as well. So, and if you're not a member, I encourage you all to join Virginia LERA. As you can see, it's a great organization. We have lots of good presentations like this one. So
Thank
thanks,
you.
everyone.
And I wanted to thank Anne for lining up such a terrific speaker for us. So
Thanks, Anne.
thank you.
Well, it's nice having a chance to talk to all of you. Now we can go and read more about the Pope.
It's an American Pope.
Yeah, I just saw the chat.
So